Hello, thanks for joining today. Today I'll be talking about navigating ownership transitions. When someone who owns a business passes away, what happens to the company at that time? What happens to the owner's interest in the company? Anyways, my name is Michael Kvistad. I'm an attorney here at Beresford Booth. And again, thanks for joining today. Like I said, this kind of involves probate, although I'm not a probate lawyer. What I practice in is business law, primarily, where we buy, sell, and form and close down companies. And there is an interplay between probate and business law when an owner of a business passes away. So without further ado, let's begin. All right, topics today will include transferring outside of a operating agreement, which is the agreement that controls a company. And today I'll be mostly speaking about LLCs. We'll be talking about transfers outside of probate, and I may touch on the Corporate Transparency Act just for a moment. All right, this is how most business owners feel when they get into a business. It's a great feeling. I love helping people get here where they're just excited to be in business, starting this new company, often with friends or family. It's a great situation. But what happens on the flip side when someone passes away? Well, here's a couple of quotes. This Karen Box with Too Many Tiaras, she says that the majority of family businesses do not survive the transition. Most. I mean, that's the majority. That's a lot, and that has to do a lot with family dynamics. And we're not going to be getting into that too much. We're going to be getting into the mechanics of how things transfer. There's another quote for people who love classical literature from Anna Karenina. Says, "All happy families are alike. Each unhappy family is unhappy in its own way," and that is true. And that can involve what we're talking about today. There are a couple different types of post-death transfers via the operating agreement or through probate. There's some crossover, and we'll touch on both of those. One option that people use in their agreements, if they know exactly who they want their business to go to, they could say something like in 6.1.1. Here it says, Tina's membership rights shall automatically transfer to her lineal descendants. That means basically her kids. And so if she has 3 children, each child will get 1/3 of her interest in the company. So if she owns a single member LLC, she's the only owner, then each child will get 1/3 of the company. If she was one of many members, suppose there is a family company that owns 3 pieces of real estate and it's owned by 4 siblings and has been for decades. And now those siblings are thinking, well, we're not going to be around forever. We want to arrange our company so my interest goes to my kids and my siblings' interest goes to their kids. We can use something just like this to get that done. Another way to do it is actually to spell out individuals' names. That can happen in that situation where there's multiple siblings that want to give to their kids. It can be where two parents have 3 kids and 3 properties, and they want to give 1 property to each child. So there's different permutations we can use there. There's also how to transfer if there's a single member LLC that is owned by a marital couple. So if 2 people are married and one of them passes away, they can just say, I want my spouse to get my interest in the business, and they'll automatically be admitted as members. And what that means is we don't have to go through probate to make that happen. Similar to the lineal descendants or transferring to the children, don't have to go through probate. But here as well, we don't have to go through probate, and that's a great advantage at times. There's also the a buyout where the LLC has language itself that says when a member passes away, the company has the right to buy him out. So there's provisions like this. It's much longer. This is like selected provisions of a buyout. But an involuntary withdrawal includes death. So if someone dies, it's an involuntary withdrawal. And in that case, this offer kicks in where the estate at that time is entitled to make an offer to the company to purchase, for the company to purchase the dead person's interest in the company. Now, in that case, it's really the estate. When someone passes away, the estate takes over. So I'll say the estate makes that offer. It says, hey, we'd like the company to buy this interest at the amount that's agreed upon. And that agreed upon amount is typically in the LLC agreement, in the operating agreement. It spells out whether that's based on, fair market value or book value or some other determination. And if the company accepts that offer, then the estate is no longer a member and the company has been paid for its interest and the company has one less member. If the company rejects the offer, then the estate is no longer a member. It becomes what's called a transferee, or in this case, a interest holder. And they're not admitted until the other members vote them in. And so that's different from the previous examples with a marital couple or a transfer to lineal descendants or transfer to individually named people, because in those cases, it can be done so that those children, those descendants, the surviving spouse are automatically members in the LLC, whereas in certain buyout provisions, there has to be a vote by the members. Another option when someone passes away is to dissolve the company. This happens with companies, often single member companies, LLCs, where their level of expertise is kind of unmatched and no one in the family can really take it over. That can include someone who arranges flowers, someone who fixes computers. Could just be something that, hey, the business is over. The assets of the business were really that person's mind and their skills. So there might be a few assets to sell and then distribute to the estate, but they have to dissolve the company. And for instance, sometimes, like in this slide here, in 7.13, sometimes in a multi-member LLC, unless all the members agree to keep the company open, when someone dies, the company will dissolve. And so when there's a dissolution, there's a multi-step process that has to be gone through. It takes some time. Notice has to be given to creditors. We have to suss out who the creditors are first, then give them notice. And it takes quite a bit of time, but it is an option and something that can be beneficial, especially if there are creditors of the business and say the business really doesn't have any positive assets. It's got just so much debt. Dissolution is a good way to kind of cut off those claimants, make sure they get paid out of the assets of the business without being able to pursue the owners, in this case, the estate of the business, for a wrongful dissolution. There are a number of statutes considering what happens when someone dies, when someone who owns an LLC dies, if they don't have an operating agreement. All those examples before involved an LLC agreement or an operating agreement, as they're also known. This just goes by statutes. It uses some different language, but basically, when someone dies, by statute, without an operating agreement, when a member dies, the interest then is considered a kind of like an interest holder, a transferee, or a transferable interest, and that's all they are. They just are a transferee at that point. Well, still a transferee, so like an estate. If an estate's in a multi-member LLC, there's no operating agreement, and someone dies, the estate takes over, the estate can still receive money distributions from the LLC, but likewise also has to make contributions to the LLC if the LLC requires money to be paid to the LLC. An estate or anyone in this situation, whether it's a PR or personal representative, can get records from the LLC. And those records could include the operating agreement if they have it. You can request that and get it, which then, as some of those examples before explained, there could be a resolution that's at hand and definitive in the LLC agreement. Lastly, I'd just like to touch on the Corporate Transparency Act. When someone, so this is a law that came into effect on January 1 of this year. And in essence, it requires business owners to turn over to the Department of Treasury, U.S. Department of Treasury, certain information about themselves, name, address, date of birth, and then like a copy of or information contained in a passport or driver's license. And that information, without getting into the Corporate Transparency Act as a whole, when someone dies, a filing is required under the Corporate Transparency Act. Corporate Transparency Act has severe penalties, including civil penalties of $500 a day. And they can, so it's important that a personal representative make sure that the Corporate Transparency Act, or CTA, gets followed as well. All right, well, thank you for your time today. I very much appreciate it. If you have any questions, please contact me. Thank you.